on the first.
But we say even on the that's not that's still wreck. Even if you I'm going to explore temporary cover, but your broker does tell you that you've got
until you temporary cover. I thought.
In a sense, he has the doubt, even though it might be generous and might be that even if the position he has communicated with the broker, the board investigations, panel lenders, and things he has, he still knows that it expires on the 11th of May 2017, and has happened. It doesn't really matter what, unless he has secured new cover. That's the only thing in that scenario. He asks for it, and that is from a regulator's perspective, from positively, I'm just not going to bother. We requested that all of these indicators of integrity are necessarily proving it. If it's more egregious, the tribunal might be more include lack of. But either way, the test is met. And then findings from the previous that there was no activity. Position advanced. Mr. Markou, through his representative terms, it was in the skeleton of regulated activity. Is a conclusion at FSC, because he won that. FSC also responsibly improved ceasing to carry on any activities. Also concerns and being expressed. All is now revealed completely wrong. '74 through to one of this decision, just to identify this tribunal gives commentary on what stood then, the tribunal to have concluded. '74 did not trade. It was very clear, again just to note this, the applicant was did not trade, did not.
It's what they find in 6, isn't it?
Yeah, exactly.
So the distinction that was sought, they reject.
FSC tribunal and was saying no distinction at all. Here, if one looks at the statement, he did the same thing, but then this business comes up. This is why the tribunal whether there's an ambiguity, and it says there isn't as to what he was saying last.
Yeah.
And we'll see so to what saw the FSC tribunal of regulated activities, and then the question. So trade that was all. Renewal. My Lord, the Chancellor, your point best in paragraph 200, which is at
260.
So 250, page 110 in the bottom.
Yeah.
It's a short conclusion, just here as part of the narrative, as part of the decision. The tribunal says, May 2017, and by coincidence, elapsed, and sought to renew, was not subsequent. That's all we have in finding, because there's evidence, frankly, and just in a position to say, and certainly no communication or anything of that nature.
The tribunal then says this would be prohibited.
Beyond what had said, I think primarily in the FSC, because they're because the argument there was the FCA's. It was about non-payment to the FCA tribunal, and the argument
from 75, it's you intervened and get the cash flow to pay the fees that we would otherwise pay.
Yeah.
Immediately started thinking, pay the fees to the fees to. They're not all the insurance premium.
Well, yeah. So it's prohibited. They haven't got any money. Whether it's prohibited by standards of the market is neither here nor there. It is it's business where lenders have said fraud in the application, and that they're going to cause for PII.
50 is by this tribunal, so I found that he took to renew it.
But it didn't, and
Yeah. So, giving the benefit, I pointed out in this case, he asked the broker because he did know it was expiring. Steps he took. He doesn't.
it's quite difficult, isn't it? Because the previous made a positive that he did not to renew.
It is.
And yet here we have nowhere decision to ask to discover on the 11th or the 10th of June that he's not going to get rid, although 50 again is equivocal, because it's not that the insurance refusing to renew, they were only at a prohibitive cost.
Yes.
A decision not to renew.
Indeed.
So what you've got is durations really. 10th of May. The insurance, there's no help covered or available. The fact that at some brokers to renew as a date there was no cover and he needed cover.
Yeah.
Situation 11th or the 10th of June, where I knew renewed, so they have renewed.
Yeah.
11th of July knows on any view there's no prospect of any cover.
Yes,
Sort of fair summary of
that's absolutely a fair summary. Why, by trying to identify dates and what the relevance is the May and July. However, cases, it just doesn't either way. Whatever benefit of the afforded, it is still circumstances and cannot point to anything which is to meet the risk of trading without period.
Yeah.
So returning then to 3 the expiry was proceedings 337. So I'm on 6 for decision. And where it says it, and 337. There is no dispute that of May. Read that, so I wrote 3 is our case. Either May or so we're advancing and 3 actual issue FSE carried on each business of any going or new PII lapse. What the applicant knew where he took any or reasonable spent his mortgage in conducting such business to make in 17. That should be the business as opposed to advisors, because for generally speaking.
They put it that way because in terms they were the ones.
Well, also that he was responsible for reviewing application because he's regulated function. This is more ground than 5.
Yeah.
They are in truth just doing it on. But in systems and control, before days, as a regulator, he was actually supposed to be these applications. 340 extracts from the witness in the tribunal, the court to this. Then 341. So written evidence, his witness business, written submission of November, conceded some business conducted FSE after 2017, after 10th of July, presumably having statements which are clear that they had this new business.
Yeah.
New skeleton argument 27, why it's all irrelevant. And then only 3 of 10 after 10th of July. Before that,
So what?
was and for 3 hearing, FSE continued to its advisors after no PII was. And then it was accepted of the conduct of ongoing this where contact prior to May 20, even if mortgage was submitted thereafter.
We don't have a figure for how many cases of ongoing.
It's quite hard to tease because we don't have a figure, but we've got examples in each category.
Okay.
And that is sufficient. As soon as you've got then in fact there's more than one the categories.
It seems to accept the July. Any view
On,
been told that there's no PII.
yeah.
And how much ongoing business?
Yeah.
The 10th of July.
Inevitably, the FSA can prove what it can files. They can't clarity of the business. There may well be more examples in complete, but what it does is evidence by business as to which the FCA. So if you've got these, it doesn't really matter what else you do because none of these in your business.
Right, so they find he's given it inconsistent and it is inaccurate.
Inconsistent evidence, inaccurate. So that came about misleading, just in terms of the regulatory compliance, and plainly see to risk the normative, sorry, the contribute to the regulatory obligation. That's why up to the question 4, 3, 4, 5 records instant evidence, the statements inaccurate, and then reject the attempt to try and the inaccurate witness statement. 3, 4, 7 rejects the evidence. 9 rejects to explain the statement. 50 in evidence, but then the final into the conclusions. One is deliberately inaccurate or reckless in giving on this topic. Now, because we accept that we found that evidence is that you want carrying out activity. We'll approach all of this. One, we nevertheless succeed. 351, we are honestly mistaken on both occasions.
You say either knew they were business without PII, or didn't.
Yeah,
And to start skating about what it was previous business or business is just trying to do an obvious lie.
the obfuscation,
Really.
my lady. So 2 points. The first is we have the misconduct, but in any approach to your the misconduct, and that's whether we're entirely because obfuscating Frank with his, which includes as the tribunal. That is a very telling of a lack of because a person, for example, a solicitor, behave in this fashion. We make why we turn sufficient a finding integrity. Tribunal says things. First, of all, say what used because well, you have to look at it. We say it's all conceived. So the final line of the page, by the time of he'd already accepted the hearing, ongoing and new business after 10th of May 2020. So that is presumably a reference to the scale document. So I think what the tribunal is, well, even though he was trying to defend his witnesses, which was inaccurate, if his scale is something completely different, he's just not really understand the point of that nature. And we say it's a strong vision in the house with which we are going to benefit off the down too far. In any event, focus all of that the question, the extent of data business. This is addressed from 5-4. This is when the tribunal is actually rejecting what they say. So, recorded 354 suggests that applications were processed by PII, because that's what they intended to suggest. We're not detail or supporting material. Then why it then goes that it's for a number of years. True, 20 difficult to prove because for all of them. But we proved it as the tribunal because okay, after the 20th, the 11th of May and the 10th of July, it doesn't really matter whether it's 20 or not. And there's some criticism.
He's a new business, yes. There must be, because what they're saying is they processed 20 applications, and you've only finished 10, and 3 were after June. Yes, doesn't help ones that were renewed.
Correct.
They actually find as a fact 5-6 that all of the applications were new business.
So that's new as well. We say no. Just in terms of
There's new.
Yeah. So proof of 10th of May. 3 submissions which were new the 10th of July. So 356 and 35 should have been, we say. There is no sensible.
As far as ongoing is concerned, there's no separate finding facts by the tribunal. Recorded in all 3 that it was accepted ongoing business conducted after the 10th of May.
20, it's very easy to say with precision it breaks down, but what we know is that there are testers, and that's enough. So others were probably ongoing, or when one looked back, they were older, but it doesn't matter what case, by reference to the compelling aspect and new business. It's very difficult how that could ever be. That's why there's on that before the college. This is when we get into my knowledge, one can see that we would accept if I had been behind the applicant, then he would be, well, how could I possibly? That wasn't a fact. So in terms of 358, it says, did you specify that the applicant could, at the time of any of the business without PII being and has advised not to conduct business after 9th of. So now that is that's our what's already been. And it says PII was not in July 27th, but he did.
Sentence is focusing on business.
Yeah.
It's focusing on the business. It's phrased rather awkwardly, but I'm just saying they were conducting any whilst there was no PII in place.
Well, yes.
The only out.
Yeah.
Well, that's
Yeah.
That's the second you've got to answer in 3B though. The first one is whether FA non-related business, what the applicant knew was aware. They are addressing the right question. Did he know about whether this was being continued during that period? Renewal of past acceptance of staff when he knows that they're in place.
Yeah. Then go on to look what his direction. Does not know what agents have followed his process new business, but we also there's as much a failure part as hers. There is then an action that responsible for the advisor on the instruction. There's a finding that there's a repeated or written lack of file supervision. The difficulty is that even in this stage, he doesn't have a positive that he's taken any step in response to the PII other than don't out new business. That's the only thing in the allegation, the risk of regulatory non to take reasonable Canada Square. And if you take any step whatsoever, he really got to go on the stage of the analysis. But then it does. 360.
Pause briefly back. The tribunal says PII was not on the 10th of July. It has to be wrong because he knew it was renewed while he may have renewed.
Correct. To be wrong on the findings. All the
And at some stage in July, he'd instructed to renew.
yeah, all implies that it's not renewed because all they've just said. So that's based on what the tribunal in terms of July, not that he didn't in July.
Well, you get findings at 360. You clarify the position held covered.
So
Obtain written copy PI placed during the interim.
yeah. Okay. So the tribunal is the steps are expected to see. Did take those steps?
All of these wrong, and then it's not reckless.
See what happens. The tribunal, so all the had tested in cross-examination. What your business? You're responsible for all of this. There's nothing at all. Single instruction.
There seems to be a sort of being puzzled by this one, judgment being a sort of an assumption on the tribunal. How cover would be continued, there would be covered, irrespective of whether or not the brokers said, "You want us to get you held covered," and then said, "I'm afraid we can't get it." The tribunal is assuming in these that until the penny dropped in July, he didn't know. That just can't be right.
That can't be right. And that plainly is. I agree with my lord. I think I also think it made an error, which was to consider reckless concerned a different question, namely whether anyone was exposed to risk of their not.
Say that, Mr. Brown. Look at 366. Failing to satisfy the interest of the mortgage customer.
Yes.
I don't think you can even on that basis.
Well, I've read this. I'm trying to work out the reasoning to say anything in terms of grounds.
Well, I think actually, look at it, that the trying to edge of intelligence, that recklessness, that is a applied recklessness test law.
Very well. Obviously, would.
I think, reading for myself, and I thought, I mean, he didn't do that. He did any reasonable person, all of those things, but it wasn't reckless.
That, my lady, I think.
On that basis, of law is to best.
Isn't the issue. It was reckless. Edged. Say it is reckless because legal test is like logical analysis for us. Well, if it's dishonest, then business. Because if Siler is a very of lack of integrity.
No.
But it suggests a lack of integrity. Would negligence matter for another tribe? It depends on the level of negligence. But here, business plainly established its negligence case. That was what the tribe did, and it did.
Taking the risk, care the risk is going to eventuate.
Yeah.
As eventuate. That's the recklessness, isn't it? When you say something without whether or not it happens. On a sign basis, well, I know there is no evidence. I am risk that my advisors will have new business and old business, knowledge that I have.
Yeah.
I mean, there are two aspects. Knowledge as a position, where it's subject to what has been, as Mr. Markou takes leave the 10th of July, it's hard to see. But the other aspect, what did it about new business?
Yeah.
And is the position cut there because, well, he did do new business.
But then he also didn't supervise them, which is
Clear. No, it's not as clear cut. Sufficiently clear is that the new business, the old business, to corruption was inadequate.
But it wasn't addressed business point.
Quite.
I mean, they just don't address in the context. Say anywhere, he never. It's clear he got them not to conduct existing with the existing business. When, for example, do alleged mitigation at 3, they only talk about the as it were, insignificant amount of new business. Just don't address existing business. Don't know.
To me, that if you've got people who are working, your boss comes to you and says, don't carry out a mortgage business, take that as a green light with renewing the old.
Precisely.
And in a sense, if there were more cases, he still responded appropriately, as opposed to what happens. Anything in respect of the old, no reasonable step. So whether in fact not is there.
Anyway, in the context of whether it's existing,
Yeah.
Instructions given 10 or 11 was, you express finding at the end of 5.9 as set up below by the applicant or written instruction, and there was a lack of sufficient.
Yes. Exactly.
So it doesn't stack up to then say, oh, well, none of it really matters.
Well, it doesn't matter and then the factors, they say, well, there weren't that many cases, doesn't matter. It doesn't matter. It doesn't matter if there was one or the other point. About what is about integrity and fitness and propriety of the individual, about whether situated, even though it doesn't matter claims made on the maybe the insurance. Again, the tribunal should have said, well, what do I do about do anything, and to give instruction for new business inevitably work. Myself is, does recklessness, lack of integrity, effective of what happened? So we say, well, it's irrelevant. Recklessness with a 374, and that's actually correct. So the risk was the unreasonable steps that he, so see 375, and then we get more things. So was notified, important thing, but thereafter criticism of the FCA 7, we didn't with the but it's not. So this is about individual has. Then 3 had undertaken to the new business from 2017. We're satisfied that that's their intention and maintain that undertaking, but believe will prevent him from ongoing business. So
even if he didn't have the insurance.
yeah. So objective standard, to some extent here. Fine. Or made the applicants have what they should do being processed and submit ongoing case approval, and did therefore continue processing his application. So positive, he said, do it.
Well, it's positive finding completely contrary in paragraph 9 of the witness.
So there's 2 points. He's saying business without not the
well, that's a he said to them, knowing that he didn't have in place, hadn't been knowing it had been renewed. He said to them, well, you can carry on with the files.
Yeah. And I think that's the reason why they've gone into it is that in skating over the business and trying to finding on the new business, because the tribunal recognised it worse, actually be taking on cases But this is still for our purposes. He is by the regions that prohibit business to be transferred. He was actually saying. 381 was you need to be aware or care, taking a reasonable of letting or failing to prevent us continue to transact business. This is where there's a different spin on the second part. If it's not in place, it's satisfied. What does tribunal reasonable risk of letting his continuing to transact business? Because it's not a risk at that point. Once he knows that there's no in place, eventuated. So the word, the second part here is wrong, because he can only say do anything. And this is why it might tribunals also was for their terms without PIR. Well, that's that conclusion. But in any event, in terms of what the are, 382 not of the risk that there be business without PIR. It reasonably but believed that the PIR be renewed. That's for they say he took it would be renewed because it had not said the opposite.
And that it would be the relevant period and would be back to cover the period.
It's all temporary. The potential problem be 2 months. In fact, he does until the back.
Exactly.
Then we but mistake that it would be renewed. Correctly does looking at the position prospectively. You don't say has been. It would be different if, don't worry, you're on, and that was not, but that's not the fact. So it's told being renewed. It's a double negative.
85, I find difficult to reconcile findings, and with 3, he didn't know his firm was conducting more ongoing business this time.
Yeah.
He took
could
it
conduct business.
Yeah.
Just doesn't.
And the second part, he reasonably believed it was in. He honestly reasonably believed it would be renewed, but it was. Then this was his 6. We accept, and he said, "I just said clients basically the step he took."
They go again at 3. The second part of it already set to it. That he basically instructed them advisors they could processing existing files. So
7, in writing, instruction in writing, instruction didn't want submissions to lend to prevent them making applications on at least 10 occasions. And 3, he's not ready. He did give care and some reasonable risk. He was not aware, assured after 11th, not even that this was. I just can't.
But the tense is he knew that he was assured.
Yeah.
Saying he would not be assured.
Correct.
Saying he still hoped assurance.
Yeah. That must be right. The fact that he hoped to be insured was sufficient. Until he's positively told him you're not covered, that's fine. Although he should have appreciated there was some risk, an unreasonable risk. This is to be very. What does that mean? Because insurance, or you have so about risk in this. What is the is it the risk of insurance that you don't get it?
It's the risk of trade. It's got to be.
Yeah, then we,
And the risk is if they had claimed a customer in the period between even on hypothesis, there wouldn't have been cover.
yeah,
The insurer would have agreed to renew since it was taking on a claim. They just disclose this to a certain.
indeed, but is also the tribunal thing. It can take a moment to say, well, probably anyway because you claim, and therefore, related business, despite what the regulators say, you can still proceed. If that conclusion was anathema, because that is basically counting a conventional regulatory regime basis that your response will be okay. That completely undermines financial services because it's just you don't need these circumstances.
I'm just looking at the instance of 3.8 trying to work out where the non sequitur, because most of the rest of that business, but I can't find reasons for thinking that it wasn't under the risk of continuing business having regard to circumstances.
Yeah. I
Is that the hope of insurance enough reasonable?
Sort of bloodless,
Yeah.
as it were.
yeah, because it's in insurance and it might anyway and all of we say well, it's complete question and the fact is in any event. He's definitely ploughing on any steps. Then complete it then. To form the authority will not be conducting new after the 9th of 394. 392, he told the FCA that have any further issues. And he says, well, he told the advisor that they denied this was rejected. Then final sentence between us discussed with the mortgage advisor they could act after 10th. He mentioned that it stopped. As far as it's relevant, after 10th, there is no, as if PII has any instruction, but a recklessness. He's told the advisors the PII, but they're not people. They do what they're wanted to do. Told them not to the business.
Well, I suppose not business has to, because they've already had to take a new bit.
Fine. Either way, he is without a shadow of PII in play. He doesn't update previous instruction to say now the position that we can out any business. There is no PII. Business is acted. So his previous order in place, and what explanation could be for that? And then they say, well, 5 we're satisfied to conduct in a complete manner. It's really a question, which is the risk is high. You're taken to negative regulated person. In what sense are you trying the business is not to II? General, broad, doing the best he can, which is not sufficient.
Well, 394 doesn't cover renewed trading.
But it doesn't. So
Yeah.
that's coming to one conclusion. Is that the of the risk of trading up PII, not the risks associated with trading up PII, but the business would trade PII, and any sufficient step, straightforward as that. On those findings, that constitutes business answer yes. Is that of a nature which indicates lack of integrity? Answer yes. Question for the Court of Appeal: are you able to conclude these facts? And we say that does not need to be limited to the Upper Tribunal, simply the final pieces of the place, because it is on their factual finding, and this court is such a part of the structure as the Upper, and therefore you don't need to remit this in order to the Tribunal to say on the finding they do.
But it's law.
It's an error.
Yeah, on the factual made, such inferences draw from those factual. That it is an error of law. Correction of that court. It's not
Yes.
to remove the tribunal. Difficult question. Penalty, I suppose.
Well,
If we were with you, as to what. But anyway, come on to that.
and all I want to say about ground, as a result of a lot of that, the court will have seen why we also has been reading. So this is ground, but it is the subject of separate analysis that begins at 07. Sorry, paragraph 407.36. The core bundle text, paragraph 407, page 136. So, all the jurisdictional questions had pleaded a reckless, fair, transparent authority and the other the explanation has to be extent of trading activity. The same question was it or not, but the next that as the has concluded, because you were transparent with the tribunal in the FA reference, transparent with your regulated proceedings, itself integrity, because it's reckless again, and if you evidence of that nature, then that should do a lack of integrity. So the tribunal 407 considered above, and they say it's outside, but to determine it, and they say not satisfied that the applicant intentionally or recklessly in his relation to no new business. And over the page, we have found this evidence taken, ignorance of the evidence which is used by the authority, accepting some criticism to the extent to which the applicant or viewed as advice files. So, speaking, they say, well, it was a mistake, and it wasn't until the applicant, his business had been doing, the applicant is that an error, then how he has a witness statement in this reference is that position. Broadly speaking, an honest mistake. Then two, that's statement for this, which was inaccurate. So we do have in tribunal says that disclosure was given that the applicant in fact realized the position. 413, on balance, state witness proceedings and evidence to the FSE tribunal has been. So it was accurate. Everyone agrees. So not that this was a result of or dishonesty. He was speaking ignorance of the true state, which he later accepted, having reviewed the presentation. And what we described as that is just not the facts. Statement as true, reference without and say I need to bring your attention to 9 and 10, false.
Is it at the beginning of these proceedings?
Yeah, at the beginning of these proceedings, 22, can swears his witness being true. So that it can't to say that he only aware of matter, or sorry, when he the matter changed, as it were, was his evidence that maintained it right at the time of. Now, a separate question as to whether he can be given the benefit in respect of that, but it's wrong to say after disclosure is given, does
the timing of the witness statement. I followed the trial. The
So
witness statement needed disclosure.
April 22.
Yes, so that would have disclosure, exchange of witness.
Disclosure.
Predated disclosure.
So sorry.
Oh, man.
I think, well,
When comes first, disclosure. Then he fails to correct.
I don't want to get that. Just double check the sequence of events because I had thought that disclosure prior to the witness. So disclosure is part of the process as well. But let me get that clear, and I'll the witness statement is April before trial. The other then paragraph 9. The applicant said just realised the effort and continue to carry out related activity.
But I mean, the is that back to the disclosure. What disclosure? I mean,
Talking about his own.
well, precisely.
I've read it. Well, the party disclosure. So I'll make the submission. Speaking, it's the applicant's files back to him.
Well, the point is that our own file would have told, or examining files would have told whether or not knew this was being written. The findings of this, he'd actually his start on writing existing. So paragraph 9 is when no amount of disclosure was going to change.
Yeah.
Because you know that. So far as concerned about new business, you shouldn't have signed a witness statement unless you checked.
Yeah.
His own.
Indeed.
And if he didn't have files, then they should have asked him
to
our own files before we witness statement, or qualified the evidence statement by saying I think they wrote in this, but I don't know because I haven't got access to files.
Absolutely. Because we're talking about presentation of the evidence. My lady put it. We say revealing in terms of recklessness and lack of interest. because if you're investigating a matter in dispute, then not only does it obviously create difficulty determining it, tends to suggest that you are not sufficiently frank and accurate level of integrity in respect of a regulated person, which is its adversary. So to you can powder dry, lead, misled, gravamen of the complaint.
And just note to that, well, it may not matter. You in fact seized all so that he could go to the office and look through them.
So we had taken made copies of the then back, and the query is that happens.
Yes.
Prepared to accept, to some extent, the applicant does not have the after the enough, or is responsible for this business. He should out what the true position is. But we're on a different, which is well, misled tribunal when he's in absolute stated in the proceedings, no new and latest activity at all. Paragraph 9. Negative statement false. The real issue. Because obviously we know that he was then going to make a statement which he'd made. So that's why the plea really looks back at misled the FSC, because it's become clear to us that's but then he maintains it, which aggravates it by continuing or contend no new business when it's patently clear.
Is there anything at those points, be it he confirmed the statement and things in the witness box, it had already been on his behalf through that this?
Well, it's because counsel is different himself, and I'm not, there's no, but instructions have been advanced through the FSC tribunal. Is no regularity. I took the tribunal in the decision before. Then a part of the skeleton, which is more, I would tend to say that not right, but the witness statement is obviously a critical part of the case. So, is there anything in the point? Yes, there's something in the point. I think the tribunal is entitled to itself ask itself, is there here which can just excuse on this basis? Maybe that's what the tribunal is trivial error, witness statement to the FSC trial, and I would like that because it's not ideal, but it does evidence lack of. My lord, as far as it goes, but it's far too generous because that's just not a very deep case before the tribunal. The FSC tribunal lets no regulated activity in place after 9th of May, 10th of May, set out in the I took people through, deep reasoned, and that's essentially in that tribunal false. We're not in territory. He's referred to the tribunal against a case which is misleading to that tribunal. Ultimately succeeded. And
64,000 as to what extent he made or was false, and I'll prove he was aware of it at the time. Say that there was a seriousness both at that time when he failed for the tribunal.
Indeed, so that would be very serious. That would be perjury. But we can say he cannot have advised, so that the risk respondent risk term is that he gives inaccurate. That senior regulated person is something which needs to be regulated. He needs to take some steps to ensure the accuracy of the evidence, the FSE trial, and subsequently the tribunal. The tribunal, as to that sits, was in a there'll be a bit of evidence, say, this is case. This is not a part of the evidence. This is a central issue. Just flat and mislead to the upper tribunal reference.
He makes a positive argument that there's no going on in circumstances in which, on his own case, instructions he's given to new business, he doesn't jurisdiction. He doesn't have the to hand, but he could doesn't inspect them to make absolutely sure, and put in caveat, unfortunately, they've taken away all the information, express instruction, no writing of new, and as far as I know, that was carried out to my knowledge and belief.
Yeah.
Those sorts of caveats.
Correct.
To correct something once the truth comes to
Absolutely.
and to examine and concede.
So we have to cross-examine over days. There's a 5 cross-examination. The true position is clear for hiding. It's a begrudged consent to the existing business. And frankly, because of the fact of the early where that allows us to plead it and be concerned about it, compounded by the response by the misleading enough, together with what has concluded, SE tribunal say, well, this person has not approached the evidence with a level of diligence. Does that mean yes? That's the next question. But that's plainly the position is that there is proper the evidence. This is a senior chief executive position, system akin to a solicitor, where a solicitor would that be excused? No.
Just going back on that point, in a written cross-examination, certainly at the beginning of evidence, a witness correct in his or her error like 9 witness statement in what as this had been the Upper Tribunal in the FSE case, the consequence of would have been that the tribunal was misled, whether or not for purposes. You do at the beginning of the sentence. I'm not being critical of Phillips at all, because the witness is responsible. Is to say, to just record straight here, when I said before the last tribunal, what I've said in paragraph 1 of my statement, just not correct.
That is what we would say to do, given the standard as regulatory scheme.
Actually, it's what you witness.
Well, you might, but whether it's
About him being a regular position taken.
Just to this, looking off his evidence, confirm the truth. If you have fundamental G 73, witness statement.
Page?
60.
Right. Okay.
Is that statement? Is that your
398.
Oh yeah, that is my square. It is.
98.
That the forensic, perhaps that I should have, but point remains the same. No, what, which is to give a full, transparent account.
Well, did it have a statement on it?
Yeah, didn't it? I think.
Must have had a statement of truth.
It had a statement on it, and it's the statement. He is adopting the statement of truth thing.
So
Sometimes ask the witness to confirm that the contents of the room. If you do fully, you will think of plenty of cases. There is a statement, and the witness is asked to confirm the statement. And there's some questions.
Yeah. Well, there's
15. There is a statement of truth, as you'd expect.
Okay.
Even if that's a statement, my same about how what we and that,
Yeah. Quite interestingly, page 400 for the bundle. You actually put him. That is right, is it not? You find statement of truth. The statement is true.
Yes.
So
This is situation you have said there is.
yeah.
If they would like to put it to me, I'm honest and candid answer for 5 years.
Okay. There.
I think the
Yeah.
Yeah.
Right. The court has a so we says well looking for the documents and we'll make those points when we'll say as to why it, we say plainly and for not satisfied on the basis of recklessly transparent but that's the conclusion has to unpick the reason fail to care, fail to give thoughtful and unreasonableness evidence. And then I think must say, well, he's just doesn't really know or something of that.
Yeah.
So he had to be careful. What
thought and care he gave.
Which paragraph?
That's 414. He was over his memory and desire to communicate his action.
the trouble is not just for the steps he's taking that evidence goes in stand saying well honest, but bother to do any proper preparation actively document.
Just came back to 74. Ask him, I assume that people will care. And he says,
Yeah. Okay, so in which case where the only point actually is this disclosure point, but all of that inconsistent with the fact and the fact that he made through to November. So we say the proper analysis then on those findings they found in evidence not identified steps is taken in order to the risk of giving inaccurate, other than the fact that they think that it's best to be on it.
They found at 4:15 take the rights now.
And they also go on at to find that he took the risk of giving inaccuracies, but that it was not up to him to do so. Which is,
I mean,
surprising.
yes. I respectfully,
Especially given what the FSE tried.
Exactly.
And this seems to be is it to his
so he says, we're satisfied that the applicant was trained to deal with transparent as he was with us.
Yeah.
So
yeah.
yes, I can assist. That's all to say. And require King or driver into the decision wants to describe, say that they are all founded. The point here is to say it's not irrational. It is a degree of the way that the conclusions that the trial on the facts then feed into its conclusions on the reference. Basically, we say a series of errors which result in conclusion. There's an error of law there. And the approach introduction that emphasises the way the regulatory system which they have in mind. The question is not their objectively compliant systems in place that things are a mortgage business. The question is the systems and control applicant is being complied with. Because this goes back to the point I made that the FCA doesn't high risk business, it's individual business who decide markets they want to operate, but they decide on the systems that will mitigate the market risk. So it's down for the business to decide.
It must be the moment of that the systems and controls in place.
Yes.
So it has two aspects. And controls that have been put in place adequate. On their face, objectively adequate. And secondly, systems and controls with.
Yes.
Which is a different.
Yes, correct. But in the second part, those controls, this tribunal apparent in the decision 8 to 9, they refer to the practice of high street mortgages.
To which
turn this up. So 7, page 17. So 8. So there's a sentence of the erroneous 6 lines down where it says the trial judgment right here requires reasonableness and proportionate practice of a high stage business, for example, a multi-stage lending business when its own policy. That is fine as it's because this is business, but conspicuously missing is that the tribunal is concerned with a particular sort of high street mortgages, namely one of very high risk mortgage business, because of the operation that's been invented by the FCA over years. Not one size for a high street mortgage. For example, a criticism of pay slips. So this is just a point. This a policy, 4 months of be required any application that complied with. For example, there are of pay slips. The tribunal says in instance it's quite 3 months, or we're not satisfied there's a breach. FSA's response work like that. The responsibility of business to systems and control are appropriate for nature or profile, in which if they 4 months are appropriate, you've got to get 4 or an explanation as to 4 months. So it says 4 months explanation as to why not.
It's not a recognised case in paragraph. I'm not sure why they matter.
18 decision.
Yes.
Well, exactly. That's what they will come in. That's not what they. The 3 months is a tribunal doing precisely because it basically just decides all of this based on its own understanding. But of course, it's a special. It puts its own special there, but doesn't actually meet here.
What they've done, in a nutshell, is this. We're in a specialist trial. We are aware that the adequate systems which apply to other business, they have levels.
Yeah.
Those levels would have been by this business, even if it apply with its own model, and therefore we think it's perfectly okay.
Yeah.
That's the thinking.
Sort of thinking. The error is to think, am I asking myself, businesses risky because it's systems and controls? Asking yourself a critical question, what does that tell you about the integrity of the because if they designed system controls but then implemented them, then that tells you on a behaviour analysis be a fit and proper case, because you can't say that this is going to do and do it. Some very compelling information, and the fact that other people might be able to be compliant to business systems and control answer that question at all. So you're looking in the wrong. We're not looking at whether it is in fact creating of mortgage fraud base.
No, sure.
This applicant, and that's the point. That if you say you tell your regulator this is going to do to assuage, but then they're not fit and proper. Having established that they're not doing it, then that's good. So this
One, if you have a system 4 months of pay, and then let's say 6 months in that system, you actually only need slips.
Fine.
So you need an explanation that started with 4. So that's overkill. Everybody else in position as I am only looks for. So I'm only going to look for 3 months. That at least.
Yeah, absolutely fine. So actually, this is unnecessary burden, competitive. Scale that back a bit. Client. The FCA is highly interventionist. Looked at all of that and taken it. But my lord, you're right. You can do that because you're responsible for. It's the responsibility sits with you as the regulator. So that's
What standing back and looking at the regulator is entitled to expect that it is satisfied with certain control systems that have been run to make businesses running past it to be adhered, because otherwise there's no systems and
no point having, and also you are not because you told us. That's what it tells you about that. But you're right. then we've got to agree a 4B about we say is unfair criticism pressing. The part of the matter is the actual is, I think, on to what is 6.3 of the
263.
yeah. As page 1, 2, 9 tab 6, so to the decision. It is said that a case was insufficiently particularised for how is the applicant what case he had to meet, and by his witness statement with any of these allegations, pleadings, did for the first time, his response to examination. We say respectfully unfair. I mean, the statement of is tab 87 bundle.
Do you want us to look at that?
Very brief, labour this point, even-handed there. But I want simply to make the point he pleaded with conventional pleading, set out all of the terms, and it was supplemental, so page 135. It's 20 pages. It has 94 paragraphs. It was months before the hearing. At no stage did the applicant ever suggest that he did not understand the case to meet, which essentially tribunal. So, paragraph 31, 1342. That
on the page 33, it's there, isn't it?
yes, absolutely. So what the tribunal was authority to produce is pleading. It sets out than particulars of claim. But it certainly the fact that the process document has not been reviewed, slips and banks not been checked, reviewed 90, they all inconsistencies and consistencies have been. There was no difference between the mortgage advice and Markou. He said that he would be advising and discussing files, and none of that happened. No records. The full mortgage fraud is missing, but in a moment. We said as a key document, anti-fraud document, not present in 2 cases, tribunals 2 complete, no review, no policies. We say that were produced as a tick box to demonstrate authority that there was rather than actually being followed. So the issue affordability for vehicle by was perpetrated. Individuals misrepresent their ability to mortgage in the payment. Recognizing checks and see across all the bills. And some of these serious, as we'll see, they're all brushed aside.
That's one of the allegations that's examples of consistency I mean, if the applicant did understand the nature of it, he could have asked you for further information about that.
Yeah, and
Specify file.
Yeah.
The dates that were different, and so I can actually see for my.
yes, it had 18 months of the statement of case. If there were any information, that's all provided, none of that was. But so that's the first point. That this also suggests the tribunal basically doing some sort of count of this, where it's actually looking then at individuals and saying to it, well, I see that there's, in terms of disease, there are steps. It doesn't matter the compliant business states receive of this explanation.
They're not looking at the right.
They're not looking at the target.
Sorry.
Okay. No, I'm just going to. What you've said in 31, right the way through, and then with submission of new business without PI. 31 to 49, saying a series of failure of kind or another, a failure to supervise or failure controls and systems. Just the tribunal 263 and 4 that it happened until an argument just doesn't stack up.
It doesn't. It's difficult to know if the tribunal was actually looking at some sort of very long schedule or that's the purpose of the individual files is to demonstrate the allegation which is set out in the case.
You do this on evidence of any in which it's all for you to do this.
Yeah.
We can draw the you're not adhering to controls.
Yeah, that's the case. You tell us why you're hearing and how either prove I wasn't adhering or but customers. I mean, that's the cost.
Or I was adhering, it just didn't happen to a particular document.
Yeah. Well, it's only 15, it's a 10% of sample, that's enough. It shouldn't be 10,000, zero. So, in terms of the specific, then, I can for deal with some of the, I can probably pay slips. Next one, because we've seen in paragraph 3, we in pleading we pleaded the pay slip.
Yeah.
So required. Again, this is to see how the tribunal deals with the 272 decision. So 271 findings there. Because this is straightforward. There aren't 4 pages. There's not too much dispute being identified. To factually not 4 months, however, no substance, although there's not 3 months. So it just doesn't make any sense. Because the policy says it's more revealing really evidence of the advisor. One sees a record final sentence of 3. This was to take 3 months. Witness evidence. Because even though he had saying 4 months, he had. Simple point. That conclusion You can't conclude that you've got a policy that says with this is 3, but so what?
In terms of the mortgage process, right, to
Yeah.
I'm afraid it is.
Document which he produced. This is how I'm going to regulate obligation. Go through the process in a note as a. It doesn't matter. It's part of the document. Month's pay slips. It's in the tribunal. Track down the record. But we can have it. But it says, and the point that you put, and then you go through.
So the fact that it's a checklist is the point.
There's a rule to comply with me. What's the point of there? It's not in the MS, the check.
I don't know, because it's disputed that part of which the charge is.
It was part of the system.
Yeah, it's part of
It doesn't really matter what document wasn't in. It was part of the system rules. And then the obvious question, was it compliant?
Unless they're saying, I'd be interested in due course, because saying the sales process to the mortgage person within the company, you must check to ensure discrepancy in financial information to you, such as to a red flag. There is something to paraphrase, and then footnote which says 4 months provision. Then see that you've got an adequate amount of to be able to tell something dodgy. You could be saying, well, that's a mean satisfying what, as opposed to 3 facets.
Yeah. So it's at tab 6, and go back to after. This point is also the next consistency. It's objectionable through the process and that there is frequency. The individual may be employed for 2 months, but they may have been employed for the previous 12. So you don't have 4, but you can never then reach a comfort that the application is hiding from other. But then the policy, and this is recorded in 5, to tab 16, is that you need to cross it, and 276, the document says will be required to be placed by any inconsistencies. I would say that it requires 4, if not 4, that's an inconsistency. Then dispute as inconsistency, tribunal conclusion which is rather difficult to follow, but it's not just something discrepant, it's something else. But we say you've got a policy, you follow it, there's inconsistencies, you process that requires you to address the relevant question. I know I haven't got pay slips, have enough other financial resources to conclude that this is a generation, and you, because I've been an accountant for the past financial act. So it's a based approach. So one can, by putting in place this, indeed, business is inevitable, that allows you to be compliant as long as you are then processes. It's just a tick box exercise. I'll just make further points. Well, I won't leave the process document, come back to it, but I'll give the benefit of the shorter agenda just to go through it before I do.
Just on, I also need
That's absolutely right. So that's the argument. This is the point that inside the MA, the tribunal referring to in 274 list, which is SP.
That's where you get the reference.
Yes, that's and this examination doesn't say, oh, well, the status when tribunal on a bit of a frolic of it, there's any significance in the Newey document, it makes
So just a picture of how it was made. With a mortgage application, the person at FS comes back and says, well, 4 months worth of your pay.
yeah.
Use the 4 months of play. They say, look, I'm terribly got 3 months worth because I've only been 3 months.
Yeah.
And I was unemployed doing something else. The person at FS says, okay, I'll look through, I'll make a note on the that this is the reason and you got 3 months of looking for something in relation to integrity or slide on the 3 months discrepancies, and I'm going to do that.
Exactly. Because then, if the lender is saying, well, we're about this file, why is it you're telling me these affordability inquiries this person has never been in? And you say, well, 3 months, pay slip, be authentic. I mean, the issue about, but what if I have information?
That's what the checklist says. If there's discrepancy with any of them, it should be challenged to provide support.
Exactly.
To see that on the checklist as filled.
Yes.
3 slips with in the comments section. So the client explains they don't need where, etc.
It's not complicated.
No.
It's thorough. You need to have that material. Most of us will have applied. You need to provide the document. But the process is to be onerous because it's very important for mortgages to be ready. It's an achievement process, but there are safety because of the fraud propensity.
Yeah.
Then consistency's point, we say the tribunal off on a fraud. We then went through details in relation to about inconsistencies. So 2.6 of page 114 so there's a point that notes will be required to clarify inconsistencies. Extremely important. We'll accept that because inconsistencies reveal risk of more because slips, if in fact slips with but purportedly authenticity suggests fabrication, payslip fabrication is a way off. So we then look at the client file. Notes.
Well, they actually identify at the top of 5, 277, the question notes were in fact they were as required. So I think what they're saying objectively whether you need.
Yes, so get into examination as to whether what are inconsistent because two factually bits of information are truly inconsistencies. Mental gymnastics is inconsistent because it's to correspond or not. The tribunal says, well, it's not a material inconsistency or word effect, just not an inconsistency. Though it is this way it becomes, I think, difficult.
Well, they engage in the sort of exercise, don't they? 286 in relation to 2 payslips, different amounts be
Yeah.
pay slip for which was updated later one. Some deposited to consider this discrepancy which required inconsistency. That was the explanation being provided. It isn't.
Exactly.
It's a speculation. Might seek to judge.
Yeah, and that's precisely how the applicant. So, well, no, and he wasn't involved to review these. Comes up with a post facto analysis. Well, for example, and these which are really striking. This example, on a Roman,
Yes.
112,000 in and out.
100,000.
Yeah, not explained.
Possibly relating to business.
Possibly.
Necessarily an inconsistency.
Which foreign currency company? Oh.
Well,
Expenses.
my first. Yeah, well, I've done cases. Anyway,
I think Mr.
but the point is, well, maybe you're right, but you know, to start supplying conditions is for the customer, and it's for the applicant to support them. So, not possibly an appropriate way to simply be actually going to discount the inconsistencies on the basis of excellence, because I'm not an inconsistent saying it's an inconsistency with a potentially explanation. Saying that doesn't the FCA's case is well. Right, these Friday, as some of them concerns. The point is that they just didn't have at all.
Yeah, well, regulatory system. The point is failure of the checks and balances. If you don't ask for the explanation, if you note it, it may be quite as serious as for it, but you've got a point on as well because it's part of the. But actually asking for an explanation, just letting it slide, is an explanation, but you are not actually operating the system.
Yeah, that's exactly. So it is seriously inadequate for those reasons. Roman 5 is 8 readers of some concern. And response, it was my friend. So I know that UFCA wrong to be concerned about the bona fides because he is my friend. And that was accepted by the Upper Tribunal sufficient. That is what is said at Roman 8. We say that's not answered the case at
Moment.
that's what is being whispered. I didn't allege. We didn't allege for.
You didn't cross-examine at all.
Well, I wonder if you in due course, Mr. rather than trying to.
That is.
How much longer are you going to be?
I'll certainly be. I'm probably 2:45.
We arise promptly. My lord and I have been to swearing.
All rise if able.